So on to our next panel, who I would like to say are repeat performers, but yet they keep bringing lawsuits and creating new law. So I want to thank them for doing that. So that's why we keep bringing them back. And so I'm inviting Paula and Paula and Melissa to speak to you on a refresher course, although there will be new information on, right to know, first, freedom of information, open records, how you can get information. Thank you both so very much for joining us again. I really, really appreciate it.
Thank you, Debbie. Okay. Hi, Melissa.
Hi. Nice to be here. Thanks, Debbie.
So I'm Paula, and I'm going to present your first slides, but I think Melissa will just do a really quick intro of ourselves. Paula Knudsen Burke with the Reporters Committee for Freedom of the Press, and I am based here in Pennsylvania, and I represent journalists pro bono in various access cases, and I get a lot of those referrals from Melissa.
And I'm in-house counsel at the Pennsylvania NewsMedia Association. We represent print and digital news media organizations across the Commonwealth, and I wear a lot of hats in that role, but one of my primary duties for PNA is to answer their legal hotlines. So I talk to journalists and editors and publishers and advertising folks all day, every day, about issues that pop up. And about half of the questions I deal with, about 1,000 a year, deal with right to know law, Sunshine Act, and court access issues. So the kind of the cornerstones of what we're going to talk about today regarding public records. And I'm happy to be here today to share some of that knowledge.
Okay, so we are going to talk about court records, some records that are out there that you don't need a right to know request for, FOIA, Federal Freedom of Information Act, and then Act 22, which is for folks who are here in Pennsylvania. And we know that there are some journalists joining us from places that are not Pennsylvania. And I just want to make sure, thank you, Danielle, for that chat there. I just want to make sure everybody knows, if you are coming from a state that isn't Pennsylvania, the Reporters Committee has compendiums on our website, which is rcfp.org, for every state in the country for both court records and public records. So you can check that out later, but we're going to go ahead and advance to the next slide. Am I advancing to the next slide? Okay, here we go. So no matter where you are in the United States Constitution and here in Pennsylvania guarantee the public and the press the presumptive right of access to civil and criminal proceedings and records. Why do we want to make sure that we have access to see what is going on in the courthouse? There are 3 reasons there on the screen, and you will get this PowerPoint later, but basically, we want to know what's happening at the courthouse, whether it's a criminal prosecution or a civil case, because it gives folks confidence that the court system is working correctly and it's not putting a heavy hand on one side or the other, that everyone is being treated fairly. And there's a case site there from the Pennsylvania Superior Court from 1993 where they articulated those reasons. But really, if we conducted trials and court proceedings with closed doors, it would be very problematic. So when we say the courthouse doors are open, they really should be, both for proceedings, hearings, motions court, and also the documents that attorneys are filing. If a record is sealed, which should be rare, it should be for instances in which the court has carefully reviewed the request for sealing and in each individual circumstance has looked at and balanced the reason for the sealing versus this constitutional and common law right of access. If there is a very special and important reason to seal or close the record, then that will outweigh the interest in openness, but it should be very rare and only when there's a reason carefully articulated. And the court has to tell the public, including you, the journalist, why the court proceeding or record is being closed. So if you walk in to cover a civil case and there's a hearing and the judge says, "Who are you?" And you say, "I'm Susie, I'm the reporter," and the judge says, take a hike. you're absolutely within your rights to question why am I being excluded? What's happening? Why is this being closed? Before a judge closes a proceeding or seals the documents, there has to be that opportunity to object and for the court to explain why. We should never, absent really compelling circumstances, see wholesale or complete sealing that doesn't have a reason attached to it. And I mentioned this earlier, so we have open courts compendiums that will give you information about every different state. So let's say you're in Colorado and you want to figure out, are juvenile proceedings open to the public? You can search and you can also compare across jurisdictions. So that's a really handy tool. I would definitely bookmark that. And it goes through a bunch of the frequently asked questions about various categories of cases, juvenile, family court, things like that, that there might be questions about whether you could attend or review the records. All right. There are laws that impact the ability to access court records. And here in Pennsylvania, the two most common are the UJS public access policy and Pennsylvania's clean slate law. And if we go to the next slide, we can see there's a link to the UJS public access policy. And essentially, this is the administrative arm of the Pennsylvania court system, the UJS, and it gives this guidance to courthouse employees across the Commonwealth so that they can understand whether or not certain things are available. For instance, attorneys are required under the UJS public access policy to ensure that confidential financial information like someone's bank account number, a credit card number, a social security number, that they are not included in public documents. So those types of things should be taken out by the lawyers before they even file the thing in the courthouse. Similarly, for minors or children, people under the age of 18, they need to be de-identified. So it would be their initials only, A, B, C, G, whatever the child's name is, we would see that those initials. And the reason for that is to protect the child. And the UJS public access policy goes through kind of describing why there are these different restrictions, but keeping in mind that the UJS public access policy must follow the Constitution. So anything that the UJS public access policy lays out isn't more important than the Constitution. Now, the UJS public access policy, and this is the same in some other states, lays out a distinction between physically going to the courthouse, walking in, and what you can find online. And in Pennsylvania, we have 67 different counties. There is no statewide civil filing system. So earlier today, you talked about the difference between various kinds of cases. For civil cases, every county does it differently in Pennsylvania. For criminal cases, there is a UJS search that allows a user to search across the entire state, but it only pulls the most basic information, such as the name of the person charged, the charges. Anything else has to be pulled directly from the courthouse. So there are restrictions on things that can be obtained online, remotely, virtually, however you want to say that. So a good example of that would be protection from abuse records. That's our civil restraining order in situations where there's a particular familial or intimate relationship. Those cannot be given out online, but they can if you walk into the courthouse. So the chart of limitations is attached to the UJS public access policy. And if you ever have questions, if you're a PNA member, Melissa can help out. I can help out on our hotline, because unfortunately we do see instances in which prothonotarians are civil court custodians, or clerks of courts are criminal custodians, sometimes are withholding records when they shouldn't be. Okay. If you would like to get a whole bunch of data from the Administrative Office of Pennsylvania Courts, the AOPC, you can get that. However, the bulk data has an entirely different policy. So if you wanted to get information about how many driving under suspension citations were issued in the state of Pennsylvania for the calendar year 2022, that would be available, but it's accessed in an entirely different way than you would under that previous slide we were looking at. So if you're looking for bulk data, be aware that there's a different policy, and the AOPC does charge money. It's not free. It's not governed by the right to know law. It's an entirely different process. And the fees can be what, Melissa? Is it? I can't remember.
I think it's $70 an hour, or maybe it's $78 an hour for them to pull. And then there's a whole set of, like, if you want something that they've already pulled, like something they pull for someone else on a regular basis, the fees are, if they're writing code to pull your information, I think it's $78 an hour. If you're asking for data that they already have for something else, then there's a set fee structure that they can give you. But the fees are significant. They're not 50 cents or 25 cents a page.
And there are some records available. The AOPC has a data page where they have little infographics and things like that. But if you want a specific query, they write the code and they'll charge you money for it.
Yes.
Rule of Judicial Administration 509 is the court's version of the right to know law, our state's public records law. This is entirely separate from your constitutional and common law right of access to court records. What this is talking about is financial records. So how many bottles of water did the court system buy? Who are they renting cars from? And unfortunately, when the right to know law was rewritten in 2008 and judicial records were defined, the definition of that only encompasses financial records for court records under the right to know law. The next category of information that is slightly broader is legislative records, and then finally all other agencies. But just know that for the judicial system, if you want to look for records about how they operate, the money side, it's a whole nother process. And we can talk about that a different time because it's a whole nother ball game. You can find information about the right to know law /509 through the AOPC. All right. Now, I'm sure many of you, if I could see you, would be raising your hands if I said, has anyone dealt with the clean slate law? Yes, the answer is probably many of you have heard of this. The law was implemented with a public policy reason to help persons who had minor convictions on their record have an easier time finding employment or housing. In some instances, they might have suffered negative consequences in finding housing or employment because they had this minor conviction on their record. So the underlying public policy reason is certainly very understandable. Unfortunately, as this law has played out in the court system, it's caused a lot of confusion. This law, clean slate in Pennsylvania, should only be reserved for low-level misdemeanors, summary convictions, which are like a traffic ticket, and charges that don't result in a conviction. They've been dismissed, withdrawn, or null prossed. However, Melissa and I have both run into occasions where a clerk of court, a criminal record custodian, is withholding either entire batches of records or significant portions because some part of that record was, I'm doing air quotes if you fell asleep, clean slated. And what clean slated means is we can't see it on the public side. We have no access. So if today a borough council member is pulled over and charged with DUI, you run a story in the paper today saying borough council member charged with DUI. 30 days later, the prosecution says, we're going to null pross this. We're going to make it go away. That entry disappears from public view unless you have saved it as a PDF or printed it out. It's gone. You cannot find it on the UJS portal. So clean slating is only reserved for minor crimes. But unfortunately, we have seen instances where, a murder, for instance, has had their, that person who was convicted of murder has had their file withheld from public view because a lesser included charge was dismissed. And it looks like Danielle's posting, Allegheny County redacted a public filing I requested because the person pleaded down, so they got rid of mention of the other charges. Yes, that's a common example of what we see. So if there's a murder charge, an attempted strangulation, arson, and something else, and all those other ones except for the murder go away, we should still be able to see the facts that led to the charges and the conviction. But often a clerk of courts is either withholding the entire file or withholding significant pieces of it because they say, oh, well, these other things were withdrawn or null pro. So if you run into clean slate challenges, please let us know. We've done some advocacy work around that, as well as at least one lawsuit that included pieces of clean slate. Melissa, did you want to pipe in with anything about that?
No, Paula and I spoke to the annual meeting of clerks of courts and prothonotarians a few weeks ago, and we made a point to say to them, clean slate requires, in some circumstances, that they take a scalpel to these records, not a hatchet. So if you're working with a clerk of court or a prothonotary or clerk of court that's taking a hatchet to these records and saying clean slate is the reason why, please let us know. I think there are things we can do to help.
So on the next slide, we're just highlighting here that serious crimes involving danger to person, crimes against families, firearm offenses, felonies, sexual offenses, kinds of weapons offenses, none of those should be eligible for clean slate. They're, in terms of the legislature's public policy thinking for this category of relief, they meant it to be minor crimes. So if you ever see a major crime like this and the clerk of courts is telling you it's been clean slated, that shouldn't be, absent extraordinary circumstances. And it's important to note that there is more clean slate legislation pending that would increase the relief available under clean slate, and PNA's Government Affairs Department is tracking that. But I would say for clean slate 1, there certainly have been a host of problems as this plays out in terms of public access.
Yeah, they're trying. The legislation that's pending right now would decrease that 10-year window from 10 to 7 years in many circumstances, and it would make the kind of the universe of clean slateable offenses much broader to encompass more things. The other thing that I think we see sometimes is that I don't think the intent of this law was to allow anyone who has been convicted of a felony ever to be clean slated ever. But unfortunately, someone who has a lengthy felony history are still having new charges subject to clean slate because they've been null prossed or they've been found not guilty of whatever these new charges, despite the fact that this person is a convicted felon with serious charges in their background. So there are a lot of things we're working with the legislature about to fix legislatively, but you have to know that the clean slate concept is extremely popular in both with both political parties, and it's starting to take root in other states. So for those of you who are joining us from other states, some states have adopted their own version of Pennsylvania's clean slate law, and there are more on the horizon. So you will, if you haven't interacted and been affected with it yet, you more than likely will be in the coming future.
All right, with that uplifting note, the next slide.
I know, I'm sorry.
It's fine. Clean slate is automated. It's run by the Administrative Office of Pennsylvania Courts, State Police, and Judges. And you can see in this next bullet point, Clean Slate has impacted a massive amount of cases. Over 42 million cases are no longer available for public view. The defendant does not have to do anything. An attorney does not have to do anything. It is literally a process that goes from AOPC to PSP to the judge. And there, as we've mentioned earlier, we are aware of instances where clerks of courts have sealed entire files because of Clean Slate. Okay, we're about to turn over to the right to know law. So we've finished talking about court records. So to recap, wherever you are, Tennessee, New York, Pennsylvania, you should be able to walk into a courthouse and say, hey, I would like to look at the thing. You should be able to walk into a court proceeding and watch it. There are some circumstances where access can be restricted, but they should be very rare. And again, point you back to the Reporters Committee Open Courts Compendium. That's the universe of court or judicial records. Now we're going to shift to talking about right to know, or the public records request. But before we go there, I just want to point out that in Pennsylvania and many other states, just like you have the ability to walk into the courthouse and proactively look at files, we also have some public-facing websites that give information without you having to file a right to know law request. One of those is the state treasury. It's actually part of the right to know law passed in 2008. There's a section that says contracts with agencies valued at more than $5,000 should be posted on this e-library. However, there is no enforcement mechanism. So if a state agency doesn't do that, we have no way to know. So you can go onto the e-library and search by agency, contractor, amount. It's a fairly decent tool. Every now and then you'll run into a redaction, which should not be for most things, particularly the amount of the contract, which we have seen in one curious Department of Agriculture contract. So that's a great place to look. PennWatch, WATCH, is a place where you can find state government employee salaries, except for the judiciary, because they have carved themselves out a special little place where you can't see any information other than the title of the job and the salary. PennWatch is much more comprehensive. Title, person's name, and salary over a chronological period of time is available. You can also search by agency and range of salaries. Pennsylvania Department of State has a host of information. Your other departments of state and other jurisdictions also likely have the same amount of information. Business filings, nonprofit filings, campaign finance filings, lobbying registration filings. Pennsylvania Department of State has a host of information that you don't have to file right to know law requests for, including things like licensure for doctors, nurses, masseuse, and a host of other occupations. The Pennsylvania Disciplinary Board is a great place to look for information about attorneys. If you type in my name or Melissa's name, you'll find out when we were licensed, what our address and phone number is. It's just a quick, if you're on deadline and you need to find a lawyer, go there. And then the Pennsylvania Ethics Commission has a ton of helpful information, including rulings, advisories, and statements of financial interest for statewide candidates, except for judges. Again, that's a different bucket. So if you're ever looking for anything involving the operations of the judiciary, it's not going to be easy to find, and you're going to have to jump through some hoops. So, but these are some great places to find basic records, not at the courthouse, not through right to know law. And there are other websites like this that have forward-facing proactive information, but just wanted to make sure we shared that with you before we go into talking about how to make a request. So I'll turn it over to Melissa.
Thank you very much. So we're going to talk about Pennsylvania's right to know law today. And when I do that, the first thing I always say to journalists is, You do not have to rely on the right to know law to get information. You can just ask, and the agency can, and in many cases should, just give it to you. You shouldn't, especially when we're dealing with clearly public records. You want meeting minutes, you want an agenda, you want a board packet, you want a budget, you want something that they're talking about at a public meeting. Those are all clearly public records. Contracts are clearly public records. You can just ask. You should just ask informally first, because once you start the right to know law process, that will almost always end up in front of an agency's lawyer. And they often assert every exemption that we're going to talk about today if they think it applies. So my first piece of information is to tell you the right to know law is there for when you need it. It shouldn't be your first instinct to file a right to know law request, unless, of course, you're dealing with a non-cooperative agency, and you will have a gauge for that based on your interactions with those agencies. But always call them or email them and ask first. Informal access is often much quicker, more efficient, and you oftentimes get information that you wouldn't necessarily get under the right to know law itself. So explore informal means of access before you start jumping through right to know law hoops. If you've tried the informal access route and it hasn't worked out, or you have an agency that is either non-responsive or doesn't give you everything that they have, the right to know law is there, and we're going to walk through what that means for you today. So the right to know law was signed into law in 2008. Most of it became effective in 2009, except for a few preliminary provisions. But primarily, 2009 is when most of the substantive provisions went into effect, and we've been living under this version of the law since 2009. So we have an entire body of case law that has developed to fill in kind of the blank spaces that we see in the statute. And the right to know law isn't a particularly long law, but it is a very dense law, and there are a lot of terms that don't have a statutory definition. So we have to look to case law to figure out what the statute means. That's a lot of what Paula does with the litigation she does for the Reporters Committee, is figuring out what the statute actually means, how it's applied in practice. So let's hop on to the next slide. So what I will say is, I know the next slide, what's it about? It's about the significant changes that we see under the right to know law. So what does that mean from requesters, from the public's perspective? Because you, the journalists, stand in the shoes of the public, and your rights are equal to the members of the public that you serve. So some significant changes that were implemented in the right to know law in 2008 were the presumption of access. Records are presumed to be public. Under the old law, they were presumed private, and you had the burden of proof to show otherwise. So here under this law, the records are presumed to be public. Another significant change is the burden of proof. The burden of proof now lies squarely with the agency to prove that these presumptively public records are not accessible under the law. We also had the creation of the Office of Open Records, which handles most, but not all, of the denial appeal. So if you say to your local school district, hey, I want a copy of the superintendent's contract, and the school district says, no, you're nosy, go away, you can take that denial to the Office of Open Records and have them make an impartial decision. You don't need a lawyer to do that. I will gladly help you. But it's designed to be efficient, quick, and cheap. And it's designed to keep people out of court. And the Office of Open Records handles several thousand appeals every year, and their caseload keeps getting bigger and bigger and bigger. So the Office of Open Records was created as a means to provide a way to keep people out of court and a way to have speedy resolution of records denials. With regard to other significant changes, the method of submissions were expressly expanded under this law. So you used to have to mail things or drop them off in person. Under today's law, agencies are required to accept emailed submissions, and that's the recommended way that I tell journalists. If you're going to file a right to know law request, put it in email, because later in the process is very time dependent, and that email timestamp can become very important a little bit down the road if you find yourself needing to file an appeal to the Office of Open Records or to the courts. The General Assembly and the courts are now covered. Paula already mentioned Rule 509. The courts don't operate with regard to their financial records, they don't operate under the right to know law. They call it Rule 509. The General Assembly is now expressly covered under the right to know law. You can get access to 19 categories of legislative record, which is a specifically defined term in the statute. You don't get things like communications with constituents or lobbyists. emails, things like that. The legislative record is primarily geared toward finances. What are they spending money on? The response time for agencies is 5 business days. The law says agencies are required to respond as promptly as possible under the circumstances, but not to exceed 5 business days. There's also the possibility of a 30-day extension, and that happens routinely with agencies. It's one of the most common complaints I hear from journalists about the right to know law is, hey, I just want a simple record. They took 5 business days. Now they're going to take 30 more calendar days. That's a problem. We're working on to address it legislatively. The law reaches contractors, third parties who are performing governmental functions. So just because an agency is not necessarily in a physical possession of the record, if it's with one of their contractors, you may still be able to reach it through the agency under the right to know law. There are 30 exemptions. So the presumption is records in possession of a government agency are public. There are 30 exemptions to that, and they deal with various categories. Most of those exemptions do not apply to financial records and aggregated data under the law. So you will get maximum access to records that tell you how an agency is spending or receiving public funding, and aggregated data. So you can't distinguish an individual within a class of data. Most of the exemptions in the right to know law will not apply. And just keep in mind that the right to know law is always going to be superseded by more specific law. So the right to know law kind of sets the floor for public access, not the ceiling. So if there's a more specific law that says something is public or is not, we will look to the more specific law for the access provisions in that specific statute. So for example, 2020 was a big year for the election. The election code has various public access provisions in it. Those supersede the right to know law and its exemptions. So if you think there's a specific law that grants access to what you want, or you want me to look for that, that would supersede the right to know law and its exemptions from public access. So sometimes that can be very helpful. Sometimes it doesn't work out great because there are a number of laws that impose confidentiality on particular classes of information. But the right to know law is supposed to be the standard statewide. If there's no other law that says anything about access, we look to the right to know law. And we'll hop on to the next slide. So who's covered by the right to know law? So Commonwealth agencies, legislative agencies, and judicial agencies. So Commonwealth agencies are your local agencies, like your school boards. So Commonwealth agencies are the big guys: the Department of State, the Department of Health, the Department of Agriculture, the Governor's Office, the state affiliated entities. Those are Commonwealth agencies. Local agencies are your school districts, your boroughs, your townships, your counties, your airport authorities, your water authorities. Those are your local agencies. They are covered under the full umbrella of the law. The legislative agencies are your Senate, your House, and a few other legislative bodies. And again, you only reach the legislative records, and there are 18 categories of legislative record. And we've already mentioned judicial agencies. You can access their financial records, how they spend and receive money, through Rule 509 / the right to know law. But they really kind of ignore the right to know law because they consider it a conflict of laws. They're a separate independent branch under the Constitution, so they have their own rules. They call it Rule 509. Next slide is what's available under the law. What can you get? So just remember that the right to know law is designed to be expansive and remedial. Remedial meaning it's intended to increase public access from the prior, more restrictive law that was enacted in 1957 originally. So we should be getting more access. So most of the definitions you'll see in the right to know law are expansive. It doesn't distinguish between formats like paper, email, text, social media, audio, video. They're all reachable under the right to know law. It doesn't distinguish between agency and personal devices. So a public official cannot avoid transparency by using a Gmail account rather than a .gov email account. The right to know law will reach records that deal with the government business or the public official's business. It doesn't distinguish between, agency and personal social media accounts. We recently had a decision from the Commonwealth Court that kind of fleshed this out. So the Office of Open, with regard to social media and personal accounts, we now have some guidance from the from the Commonwealth Court, which is a step below Pennsylvania Supreme Court. The Commonwealth Court kind of fleshed out what it means to have a to have access under the right to know law to a public official's personal social media account. And there are a number of factors to consider. And it's basically, everything in the kitchen sink you can consider, really. It's expansive. The Office of Open Records was using a more limited test that I think worked better in favor of access, but the Commonwealth Court has said you have to look at a number of factors, including whether or not you look at the totality of the social media page. Is it mostly personal business? Is it mostly official? Look at the post itself. Is it is it official or is it personal? Whether or not you have to look at whether or not the content actually has to do with the public official's role in government. There's a number of factors that were laid out, but we now have a test to look at whether or not a public official's personal social media account can be accessed through the right to know law. But what really matters is it a record? And if it is a record, is it a public record? And those two terms are specifically defined by the Act, and we'll talk a little bit about that on the next slide. So what's a record? A record is information, regardless of its physical form or characteristics, that documents a transaction or activity of an agency and that is created, retained, or received pursuant to law or in connection with a transaction or business of the agency. That's very broad, but we have agencies every day, including today. I got a note from a journalist dealing with a denial where an agency will say this is not a record of the agency because we think it doesn't deal with the business that we do as a government entity. And there's a whole body of case law on what that means. But for your purposes, if it has to do with the public official's duties or the agency's duties, the presumption is it's going to be a record of the agency. What's not a record? So any information that's confidential by law, so there's some other specific law or court order that makes it public or non-public, makes it non-public, is if it's subject to a lawful privilege. So for example, we talked about a reporter's privilege, right? Earlier in the day, the reporter's privilege allows you to have a confidential source. That's a lawful privilege. That would make a right to know law request or a piece of information under the right to know law non-public because it is subject to a lawful privilege. In the right to know law context, the most commonly asserted privilege that we see is the attorney-client privilege, because you will often see agencies communicating with their attorney and seeking out and getting legal advice. You can't, if it's subject to the attorney-client privilege, you cannot get access to it under the right to know law. So those would not be records for purposes of the right to know law. But most of the records, most of the information in possession of a government agency will be a record, and you'll get through that first initial part of the test. So on the next slide, we'll talk about what is a public record. So is it a record? Is it a public record? So if it's a record, the next step is it a public record? Now, we talked about these 30 categories of exemptions, and I'm not going to read all the bullet points there. There's 30 of them. Even if a record is exempt, that doesn't mean you shouldn't ask for it. Ask for it anyway, even if you know it's exempt, because an agency can always grant you access to an exempt record as long as there's no other more specific law that says they can't. And oftentimes agencies will make that discretionary disclosure when it serves the public interest. So if you say to them, hey, look, I know this record is exempt under 708B7. I think you should release it anyway, and here are all the reasons why I think you should do that. If you know you're asking for an exempt record, make a public interest argument as part of your request and say, here are all the reasons why it's good to release these. Here are all the reasons why it serves the public. Here are all the reasons it can help. That may help illustrate the mechanism and why they should use the mechanism under Section 506D of the law. That is the mechanism that allows an agency to release an otherwise exempt piece of information when it serves the public interest. And again, if there's no other more specific law that says they can't. On to the next slide. So what do? How do you file a right to know law request? So what does the law require? You have to address it to the agency's open records officer. It's got to be sufficiently specific, and you don't have to include a reason why you want the record, and they can't refuse to give you a record for not providing that information. Sometimes it's helpful to have a conversation with the open records officer and say, hey, look, I don't know what you call it, but here's what I'm looking for. It's a good idea to try to have that conversation with the open records officer at the agency before you file, because if they don't understand what you're looking for, they're going to bounce it. for lack of specificity or some other nonsense reason. So conversation. This is not intended to be an adversarial process. You can talk to them as much as they are willing to talk to you. You should try to do that to work out terminology, scope, timing, things like that. But we'll hop to the next slide and talk about where to send your request. So you have to, we're talking about specificity here. That's the most common stumbling block. When I hear from journalists, it's because they've been denied for a lack of specificity. Don't go on fishing expeditions, guys. If you don't know the records you're looking for, you don't know what universe they might exist in as part of the agency's body of records, you're not ready to file a right to know law request yet. So you have to, so the Commonwealth Court, what the law says is requests have to be sufficiently specific. It didn't further define that. So we look to case law to fill in the blanks. And case law has said there are 3 factors to help determine specificity. They're not required in all cases. All 3 are not always required. But in a practical sense, in everyday, life, what I see is an agency, when they get a request, they will go through these factors. And if all 3 of them aren't there, their first reaction is to deny for specificity. So if you can give them these 3 factors as part of your request, you are unlikely to get a specificity denial, or at least less likely. So the first factor is a subject matter. You have to identify the transaction or activity of the agency for which the record is sought, the scope of the request. What are you looking for? What body of records are you looking for? So type or recipient, and a time frame. And that's the most flexible. And that will have an impact on whether or not the other 2 are specific. So if you have a time frame of 15 years, your other 2 criteria better be pretty narrow. If you have a time frame of 48 hours, courts will be much more flexible on specificity with regard to the subject matter and the scope. So those are the 3 factors. If you can put them into your right to know law request, you should. It will save you a lot of time, typically. Again, the courts will take a flexible case-by-case contextual approach, but again, if you can use the 3 factors, you should. So let's hop on to the next slide. So what are tips on specificity? Again, don't go on fishing expeditions. Don't use terms like any and all, including but not limited to. Try to avoid legalese if you can. Providing only keywords or search terms has been an issue on specificity for journalists in the past. If you're using keywords, or you want to connect them to a subject matter, and I know that's not always possible based on what you know from your sources or your news gathering, but if you can, you should. Don't request lists of something, because if they don't already exist, the right to know law doesn't make the agency request them. It's okay to say I want a list, but you should also say, if a list doesn't already exist, I want these records that would allow me to create my own list. Use party names and or positions to the extent possible to help define your scope. So just saying, I want all of the teachers' emails that deal with a particular subject. I don't know, if I'm the right to know law officer at the agency, I may not know who you mean. You have to tell them all the teachers who deal with a specific topic, all the math teachers, for example, talking about this piece of curriculum, or all the librarians talking about this book policy, or whatever your subject matter is. Try to do that. Party names, so you may not know the names of the people in those positions, like you may not know the mayor's assistant's name, but he has an assistant. You may not know the press officer's name, but there's a press officer, right? Use names or positions whenever possible. Don't ask questions. If you ask a question, if you say, how much does the superintendent make to your school board, they can deny it. They don't have to answer your questions in the right to know law context. They do have to provide records. So instead of saying, how much does the superintendent make per year, you want to say, I want a copy of a record of records that show the superintendent's salary, or I want a copy of the superintendent's employment contract. Don't ask questions because they can just deny access to that. Next slide, we'll talk about where to file. Again, you have to go to the agency's open records officer, and every agency has to have one appointed. There's a list that's linked here. The Office of Open Records tries to keep track. The list is notoriously inaccurate because it depends on the agencies themselves to send the information and keep it accurate. check the OOR's list, then go to the agency itself and say, hey, look, I want your right to know law official's name and contact information. Please provide it to me. It's also supposed to be on their website. Many times it is not. We have SEPTA, for example, has no right to know law information on their entire website, not their contact, not their agency, right to know law officer, not their right to know law policy. Those are things that are statutorily required to be on their website. They're not there. Like with the Treasury Department, there's really no enforcement mechanism to kind of police that. So just know that it's supposed to be on their website. It may not be. Even if it is, it may still be wrong. Try to confirm directly with the office, with the agency, the contact information. Because if you send it to the wrong person, there is really no affirmative duty that they pass it along to the right person. So try to nail down who you're looking for before you file the request. Next slide. How to submit. My recommendation is submit via email whenever possible, because it gives you a verifiable timestamp that you can look back on when timeframes become an issue. Because the deadline for response, that 5 business days, that doesn't actually start to run until the open records officer at the agency actually receives the request. So if you drop your request in the mail, who knows who knows how long it's going to take to get there, or how long it's going to take to be internally processed to reach the OOR officer's desk. It could take 2 days, it could take 7. We don't know. We don't have any way of knowing. But if you email the office, the open records officer directly, you have a pretty good idea of when it's hitting their inbox. Again, email is the quickest and most easily tracked submission method. Next slide, agency response. So once you've done that, you've been specific, you've sent it to the right person, you've shipped it off via email, what happens next? The agency has 5 business days in which to respond to that email. In that 5 business days, if they don't respond, it's deemed denied, and you can pursue your appeal rights to the Office of Open Records or other appeal agency. In that 5 days, they have to grant the request and provide a fee estimate, deny the request and provide a legal basis for the denial, as well as your appeal method, or they can request up to 30 additional calendar days under Section 902. That happens regularly. They'll take an additional 30 calendar days. If they take that additional 30 calendar days, they can't just say, we'll see you in 30 days. They have to provide the reason under Section 902 for the delay, a reasonable date that they can be expected to respond, and an estimate of applicable fees owed when the records become available. If those 3 things are not in your 902 response, they haven't complied with the statute. Let's pop on to the next slide. So what if your request is denied or deemed denied? They either don't answer or they tell you no, you can't have these records. You have 15 business days, 3 calendar weeks, from the mailing date of that denial in which to file an appeal. Most of your appeals will go to the Office of Open Records. There are a few situations that will go to a special appeals officer for the district attorney. If you're dealing with a local agency and you've got a criminal investigation denial, they'll go to the DA's office. The independent agencies, the Attorney General, the AG, the State Treasurer, and legislative and judicial agencies all have their own appointed appeals officers. But again, the Office of Open Records is your typical place to start. And if you misfile, the Office of Open Records typically will forward it on to the right place. But always check and make sure you're filing with the right appeal office. So there's a question here. It says, what options do you have if the law does not specify a period of time for a response and there is no administrative process to file an appeal? So that wouldn't be under Pennsylvania law typically. If you're dealing with a law that doesn't have a specific time or appeal process, what courts have done is they have used the right to know law to fill in the blanks of these other laws. So say you have a law that says this record is public, but it tells you nothing else. Then you would look to the right to know law's mechanisms to fill in the blank. So you'd use the right to know law's time limits. You'd use the Office of Open Records if you need to file an administrative appeal. The courts have determined that the Office of Open Records is the appropriate place to do that for many other types of statutes that just have blanks, right? The Elections Code, OOR handles those. There are provisions under various. So if there is no Office of Open Records, so are you dealing with another state? If you're dealing with another state, if you're dealing with the other state, I'm not another state lawyer. I know about Pennsylvania. The Reporters Committee for Freedom of the Press has a hotline like I run here in Pennsylvania. They can assist you because some states have an OOR, other states don't. Paula, do you want to weigh in on that quickly?
I just wanted to say I'll drop the link for so we have two compendiums, the open courts and then the open records. So for the open records one, sometimes if you call our hotline, we'll say, hey, go to this, but it's go and look at the law. It's really good. And yes, it's true. We cannot represent at the Reporters Committee everyone who calls in, but we try to steer them out to our resources. So at least you can see, what does the law say? There are some states that have no Office of Open Records, like New York has a FOIL office that is advisory in nature. So it's just going to depend. I guess move here to Pennsylvania. That's your answer.
Here's the other thing. Some of the other, like PNA is for Pennsylvania journalists and news organizations. Many of the other states have a PNA equivalent. So there's the Connecticut Press Association, the New York Press Association. Many of those work with or have on staff an attorney like myself who may be able to help you. So if the Reporters Committee can't, your state press association in whatever state you're dealing with may have resources who can help.
Can I ask a timekeeping question? Are we over or are we on?
I was just about to interrupt you.
Okay.
So I don't know how much more you have. Is it possible that, can you do it in 5 minutes quickly?
I think so, because Act 22 is, if you want law enforcement video, so that is police dash cam video, police body cam video gathered in a law enforcement agency like a prison. Pennsylvania's legislature removed that from the right to know law and put it into Act 22, which creates a separate request mechanism. The most important thing to remember about law enforcement audio or video, if you want it, you have to file your request within 60 days of when that video was gathered, audio or video was gathered. If you do not, you are time barred by Act 22. The factors, what you have to do for Act 22 is listed there. We'll hop to the next slide. The Office of Open Records has a fillable form that is linked here. If you want to make an Act 22 request, use the OOR's resources on Act 22. It walks you right through the process. But the thing I want you to remember most is 60 days. 60 days is the time limit. 911 calls do not fall under Act 22. 911 calls, the audio and the transcript are specifically exempt from public access under Section 708B21 or 708B22. There's an exemption in the right to know law that says agencies do not have to provide the audio or the transcript of the audio unless they deem it serves the public interest. So they can. So if you're asking for 911 audio or a transcript, make a public interest argument as part of that request. 911 time response logs are expressly public under the right to know law. They have to provide those. Let's hop on to the next. FOIA. FOIA is like Pennsylvania's right to know law at the federal level, and I think this is, if not this is the last, might be the last, next to the last slide, so we're pretty close, Debbie. FOIA applies to federal agencies. And it operates much the same way as the right to know law. The presumption is it's not public unless an agency can assert an exemption. Next slide, there's lots of information on the FOIA wiki. Filing a federal FOIA request is pretty easy. I don't think it's as complex as doing a right to know law request, but there are plenty of landmines. Do you want to hop in, Paula, and talk a little bit about FOIA?
No, because we're short on time. Just
Okay.
to tell you, there's a ton of information on the FOIA wiki. I mean, more than you could ever want to know. FOIA is available all across the country for federal public records requests. So here, for instance, in Pennsylvania, if you wanted both state environmental records and Environmental Protection Agency records, you could do a right to know request and a FOIA. So one to DEP and one to EPA. So keep that in mind. You can do both. They work well together. Maybe you get something more quickly in the state process, but you get something longer over in the federal. So it's another tool in your toolbox.
Okay, and I am going to cut you guys off. It's
Okay.
5 minutes after, but thank you so much. I truly, truly appreciate it. We will make the PDFs and slides available to everyone. Thank you for joining us. Our website is pmconline.org, and have a great day. Bye.